Good evening, everyone. Thank you and welcome to everyone for attending the University of Manitoba Alumni and Friends Learning for Life program. My name is Tracy Bowman. I'm the Executive Director of Alumni Relations and a very proud alum. If any of you have attended any of our Learning for Life sessions before, particularly our virtual sessions, during the height of the pandemic, you would have seen my face, and the backdrop would have been my dining room table, my dining room wall. And so happy to be able to offer this both in person and virtually. So before we begin, I'd like to acknowledge that the University of Manitoba campuses are located on the original lands of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and on the homeland of the Red River Métis. We respect the treaties that were made on these territories, we acknowledge the harms and mistakes of the past, and we dedicate ourselves to move forward in partnership with Indigenous communities in a spirit of reconciliation and collaboration. As alumni, we play a critical role in supporting truth and reconciliation in our lifelong connection with the University of Manitoba, and we're committed to continuing learning and doing our part to share in the process of reconciliation. The very fact that you're here attending this session, whether in person or online, demonstrates your commitment to learning more to advance reconciliation, and you recognize that this journey is a shared responsibility. So just a few housekeeping things before I get into before I introduce our speaker. So all of you have already, thank you for those who are in person, you've grabbed yourself a cup of coffee, tea, water, cookie. Help yourself throughout the lecture as well as afterwards. That is there for you. If you have questions, Mark will entertain questions at the end of the presentation. So those of you joining us online, make sure you enter those questions in the chat on Zoom. We are monitoring them and we will put them on screen. And those of you in person as well, we will have 2 mics that will be, my colleague Amy and I will be running around to make sure that we grab your questions. And also a big thank you to IA Financial Group, who is one of the University of Manitoba Affinity Partners, and they are a sponsor of the Learning for Life program. And so their generous sponsorship helps offset the costs of this program. So before I do introduce Mark, and I'm only going to have a bit of an introduction because I know he likes to introduce himself, I wanted to share why this topic and why now. So as you may know, the University of Manitoba is one of the most prominent voices in Canada's conversation on reconciliation, social justice, and human rights. The month of June, as you probably all are aware, is National Indigenous History Month, and next Wednesday is National Indigenous Peoples Day. We're also very proud at the University of Manitoba to be able to host the National Centre for Truth and Reconciliation, or the NCTR, which is a national treasure that preserves the stories and records collected by the Truth and Reconciliation Commission. So the TRC was created, again, as you know, to listen to survivors, their families, communities, and others affected by the residential school system and educate Canadians about their experiences. So after hearing from more than 6,500 witnesses, in 2015, the TRC issued a comprehensive report documenting the residential school system. And that report, as you also know, includes 94 calls to action that speak to all sectors of Canadian society and are meant to aid our national healing and process in a variety of ways, including acknowledging the full, horrifying history of the residential school system and creating systems to prevent these abuses from ever happening again. And so call to action number 45, which is what we're going to be learning about today, is one of those calls to action. It calls on the Government of Canada to reaffirm the nation-to-nation relationship between Aboriginal peoples and the Crown, and why it's so important that this history be part of our civics education. And the University of Manitoba is poised to be a hub of research and knowledge in Indigenous law and economic reconciliation, which will play a really pivotal role in the university's response to call to action number 45. And so our speaker today, Marc Kruse, he is a University of Manitoba graduate from the Faculty of Law from 2015. He is also the Indigenous Legal Studies Coordinator here at the faculty, and he will be sharing more on this important topic. So as I said, he likes to introduce himself. So with that, over to you, Marc.
Well, good evening, everyone. Thanks for joining us in person and online. So I will be trying to click along with it on my computer as well, so hopefully there isn't too much tech issues. Yes, so my name is Marc Kruse, he, him pronouns. I'm English, Irish, and Soto. I like to acknowledge my positionality of reclaiming my identity. I was raised by my English and Irish maternal family. Although I was always aware of my Indigenous side of the family, I am a member of the Muscowpetung First Nation Treaty 4, sort of in the Fort Capel region of Saskatchewan. So I'm a practicing criminal defense lawyer as well at Rees, Dyck, Rogala Law. I did get my law degree here from Robson Hall, and I was hired as the Indigenous Legal Studies Coordinator in August of 21. It's a new position, sort of showing the leadership of our law school in acknowledging the need for Indigenous legal orders to be part of our education. And also, it's not just a curricula issue, it's also our space and place. So what does Robson Hall look like? How friendly is it to our Indigenous students? So part of my job is trying to find pathways in and out of the law school as well. And so this talk falls in line sort of with that idea of letting the community know what's happening at Robson Hall. So some of our successes already is we created the Truth and Reconciliation Action Team. It's over 20 members of practicing Indigenous lawyers, mostly from Winnipeg, and the Honourable Murray Sinclair. So I meet with them sort of quarterly to discuss what's going on at Robson Hall. They review any sort of curricular changes, any hiring decisions. So it's not just my voice speaking for all Indigenous people. We've created a community and a hub where a multitude of voices can be in play in these sort of things. And so since I started, our biggest success, I'd say, is that we have a mandatory Indigenous course now on the books. It'll be a second-year course. So starting in September, every second-year law student will learn some of the things you're going to learn tonight. And, tonight's a little shorter, obviously. We're going to run through a bunch of history real fast. But in our course, it's over the September to December term. And I co-teach that with our two new Indigenous hires, Professor Daniel Diamond and Dr. Leo Muscowpetung. And so it's developed to have that sort of cooperative feel. So even though we have a main lecturer, Daniel and myself are in each, or the three of us are in each class, and we'll have the opportunity to sort of chime in and give our own remarks. And we've kept it so, even though it's going to be a large course, that we'll still have group discussions and the ability for students to engage in every class with the material that's presented. So in framing this talk, just at first a reminder that we often talk about reconciliation, but that truth part does come first, as the Honourable Murray Sinclair likes to remind us. So I always like to make it a conjunction. We can't do reconciliation work without a larger conversation about the truth, not just of the harms, but also all of the ways in which Indigenous people helped shape Canada in its early pre-Confederate days. So we're going to be talking about that history as well. So we're talking about the Call to Action 45, and in part it's because I haven't heard a lot of national conversation about this issue, and I think in no small part that's because most Canadians don't know the history of the Treaty of Niagara. So we'll go through this, right? And so they're calling upon the Crown to have a royal proclamation of reconciliation based on that nation-to-nation agreement of the Treaty of Niagara, and it needs to be reaffirmed. And so that needs to be not limited to these, but necessary conditions of that, to be repudiate concepts used to justify European sovereignty over Indigenous lands and peoples, such as the Doctrine of Discovery and Terra Nullius. Not too long ago, we had the Pope come out and repudiate the Doctrine of Discovery once again. There's a complex history of the Catholic Church and the Doctrine of Discovery, and there's a larger project I'm developing on that history as well. But from my perspective, it's clear that to the Doctrine of Discovery and Terra Nullius, we're not actually the grounding of Canada. It's the Treaty of Niagara and the pre-Confederate treaties and those relationships that were here before Confederation that actually grounds Crown sovereignty. The Terra Nullius and the Doctrine of Discovery is something that comes much later in Canadian common law, and it's a legal fiction that most Canadians in our justice system is holding on to. Again, in no small part because we haven't learned our Indigenous history and we haven't learned about the Indigenous contributions to Canada. So we'll be talking about some of those things today too. In point two, the United Nations Declarations of the Rights of Indigenous People should ground this framework for reconciliation work. And so UNDRIP is something that we're discussing a lot at law school. The TRC is doing a lot of research on this as well. And we do have the UNDRIP Act before the legislature, and we're supposed to be getting our action plan coming at the end of this month sometime. So we'll see if that act will actually get some teeth and will really get some real change and sort of wrestle with how our common law can include Indigenous legal orders and some of this history. Point 3 of this call to action is to renew or establish treaty relations based on principles of mutual recognition, mutual respect, and shared responsibility for maintaining those relationships into the future. So I'll unpack this a little more when we talk about treaty interpretation and how we include Indigenous perspectives when we talk about treaties. And also a recognition that the pre-Confederate treaties that we'll be discussing obviously didn't include all nations. It was only the nations that the settlers had contact with at that time. So moving forward, we would need to include the Inuit, the BC folk, and all the other nations that weren't part of these original agreements. But again, unpacking that history and those times means that we need these sort of meetings to go forward. And then 4, reconcile Aboriginal and Crown constitutional and legal orders to ensure that Aboriginal peoples are full partners in Confederation, including the recognition and integration of Indigenous laws and legal traditions in negotiations and implementation processes involving treaties, land claims, and other constructive agreements. So this one's very dense, but the way I read that is if we're going to be talking about how Indigenous folk are and always have been partners in Canada, in our Constitution, in our Confederation, we are going to have constitutional questions. We're going to have to ask ourselves, you know, are we able to open up our Constitution and allow jurisdiction for Indigenous nations? And what would that look like? And so, again, that's why I want to talk about Call to Action 45, because that will be the start of those discussions and processes. Let's have that Royal Proclamation of Reconciliation, call nations together with the Crown, and start talking about how we move forward and go through the condolence ceremonies that are necessary to review and go through the harms that have been done by the Canadian state, or the Crown, depending on which time in history. So we're going to talk a bit about understanding treaties. All of this work comes from Ame Craft's work. She is no longer with Robson Hall, but while I was there, I was fortunate enough to take a few courses with her and a directed reading, so I got to work with her one-on-one. This book, Breathing Life into the Stone Fort Treaty, I believe is based on her master's thesis, which she published. And it's the first history that includes the oral history of the First Nation partners of Treaty 1. And also, I believe the Catholic Church also found a diary of one of the scribes at the time. So there was a more fulsome history that she was relying on for this book. So all the comments coming up are from her work. So when we're discussing treaties, we have to acknowledge that treaties are solemn agreements between peoples. In order to interpret and implement a treaty, we look to its spirit and intent and consider what was contemplated by both the parties at the time that the treaty was negotiated. Both parties' understandings of the treaty need to be taken into account in its interpretation and implementation. Obviously, we're most often talking about Crown and Indigenous relations, but we also need to consider that when we look at the treaties between individual nations as well, because there's many partnerships and friendships before these treaties were extended to the Crown and other settler folk. So she argues today Indigenous interpretations of treaties are needed so that we can continue to breathe life into what are essentially relationship documents. While accepting that past interpretations have resulted in significant disagreement, understanding the treaty requires depth, considerations, and knowledge. To understand the treaty is to know more than the written text. And so what she's talking about here is a recognition that most of these treaties, definitely all the ones I'll be talking about today, were following Indigenous methodologies and perspectives. So it was under Indigenous legal orders and jurisdiction that the parties were gathering together. These negotiations would have been done in ceremony. A pipe would have been shared, the spirits would have been called, the ancestors would have been asked to be there, and an acknowledgement that this was much more of a kinship relationship. So when we talk about treaties, our Supreme Court has said that they're sui generis, so they are of themselves. They're not international treaties, they're not contracts, they're not other things. But what's really important there is to understand that treaties are not a frozen in time document. They're a relationship document. I like to think of them much more as a marriage certificate. It's the beginning of a relationship, not the end. And it's the beginning of a relationship that needs constant renewal and communication for that relationship to stay and be successful. And so from our Indigenous perspective, Indigenous people always viewed treaties as an agreement to adopt settlers into a kinship relationship with them, defined primarily by an obligation to share in the bounty of Mother Earth. That sharing relationship forged between the treaty families and the Creator is a covenant that cannot be breached and cannot be voided regardless of action or inaction. So these treaties, the pre-Confederate and the numbered treaties, are sacred documents for Indigenous folk. These were agreements that were made in the eyes of the Creator in ceremony, and so it's not like a common law legal jurisdiction. It's not like a breach of contract where you can sue for specific performance or something. This is a much stronger covenant, and arguably, for myself and many other Indigenous scholars, the actual formation of Canada comes from these documents. Another important note here is that kinship relationship. So from an Indigenous worldview, we are in a kinship relations with all things, even things that from a European's perspective or settler perspective would be considered inanimate. Rocks, water, sky, earth, all of these things are animate, have their own spirit and intentionality. If you're a philosopher like me, they also have their own telos, so there's a purpose, they intend things. And we're in a relationship with those kin as well, and that comes with obligations in care of that. And also that word bounty of Mother Earth. So Indigenous people were always coming from a place of plenty, not a place of scarcity. So that's another sort of competing worldviews that happen between settlers and Indigenous people. From an Indigenous perspective, Mother Earth gifts us all things that we need to survive, and we ought to respect that. So if you can imagine, instead of thinking of nature as a resource for our extraction and only our extractive purposes, Indigenous folks see Mother Earth and all of those things we call resources as kin. So we have to treat them with respect. And also seven-generational thinking. From an Anishinaabe perspective, there's always, if I'm making a political decision, it's for 7 generations ahead. It's not for our immediate use. It's for how is this going to happen and how is this relationship going to be good for future generations, not just for us today. So some of these ideas are in the background of any treaty negotiation that's happening or has happened in Canada. And another part of this history is, for quite some time, the Canadian settler narrative was one that said Indigenous folk were not political beings, did not have laws. They were primitive and savages in need of salvation, and they were bringing this worldview to them. We get that from the Doctrine of Discovery and some of those earlier documents that tried to justify some of that worldview as well. So it's important to note that prior to the arrival of Europeans on Turtle Island, Indigenous peoples had long-standing diplomatic relations amongst different groups within their nations, as well as with other Indigenous peoples and nations. These relationships persist to this day and are the foundational indicator for Indigenous diplomacy and constitutionalism, I'd add. They illustrate Indigenous principles of normative ordering that were applied to the making of these peace treaties. These treaty processes were grounded in worldviews, language, knowledge systems, and political cultures of the nations involved, and they were governed by the common Indigenous ethic of justice, peace, respect, reciprocity, and accountability. So in some of these discussions, there is some of that pan-indigeneity that goes on, and so we want to make sure that we resist the notion that there is one Indigenous nation or one Indigenous person. The Crown is often looking for that one person to come to the meeting to make the decision for all Indigenous people, and that's just not under Indigenous protocols or methodologies. You can only always speak from your own campfire, from your own experience, and it's a much more direct democracy kind of political structure. But that being said, most Indigenous nations do share that common ethics of peace, respect, accountability. There's the notion that Mother Earth, depending on the creation stories, is always a mother. It's always a giving entity. And so, again, as a philosopher, there are certain transcendental ideals, certain concepts of justice and peace and truth that I think are universal, and I think Indigenous people would argue for all people, not just Indigenous nations. So one of the examples of this prior diplomacy between Indigenous nations is the Haudenosaunee confederacy. And our oral history says that this confederacy has been in place since time immemorial. And the story is that of the peacemaker who was sent by the Creator to spread the Krawu, or good mind, with the help of the Ayanwata, commonly known as the Hiawatha. The peacemaker taught the lessons of peace to the Haudenosaunee. Traveling from the warring communities to communities, they both succeeded in persuading the chiefs of each nation to join the Great League of Peace and founded the only government with a direct connection to the Creator under these nations. They asked each clan mother of the tribe to present their chiefs. The peacemaker then placed deer antlers on the heads of each to symbolize the authority of those 5 nations. The Mohawk had 9 chiefs of the bear, wolf, and turtle clans. The Oneida had 9 of the bear, wolf, turtle clans. The Onondaga presented 14 of the turtle, snipe, bear, hawk, deer, wolf, eel, and beaver clans. And finally, Seneca presented 8 chiefs from the bear, snipe, turtle, wolf, and hawk clans. The Mohawk, Undenga, Quagga, Seneca, and Odanga accepted the longhouse as their symbol of unity. In the Onondaga community, the peacemaker planted a tree named the Great Tree of Peace. He directed the chiefs of the council to sit beneath the shade of the tree and watch the council fire of the confederacy of the 5 nations. He told them that all issues concerning the confederacy would be discussed and deliberated under this tree. So I'm going to unpack some more of this metaphor with some of the wampum in the next few slides. But it's clear here that even though they were unique nations, all of these nations had a clan system typically assigned with an animal, bear, wolf, turtle, for example, and each of those clans would have a specific knowledge that would be passed on within those clans. And then under deliberations within those nations, they would have a representative of each of those clans to speak for their clan on deliberations on whatever issue it may be, whether it was hunting or a war or sort of intramural disputes amongst their own members. And this actually creates a formalism, which again I'll unpack in a little bit here. So the symbol of the tree was again more than just symbolic. It's to say that the roots outstretched the tree to the north, south, east, and west, and were the great white roots. The peacemaker declared that any nation choosing to follow the guidelines of the Great Peace should follow the great white roots and make themselves known to the chiefs of the confederacy. If they promised to obey the laws of peace, then they would be welcome beneath the shade of the tree. And so that's that welcoming nature of this as well. And on the last slide, we talked about the longhouse being a symbol for them. And one of the main features of a longhouse is you can always add some more additions of rooms. If you have more people that want to join, there's always a space for the stranger, as long as they were willing to follow the Indigenous legal orders of the land. And they also wanted a symbol that would say, if you want to join our nation, follow the roots. So there's a pathway to join in this confederacy. And for further symbolism, there was a tree. In the tree, there was an eagle placed up top to see far and alert the confederacy of approaching enemies. And then beneath the tree, the peacemaker asked that all men throw in their weapons to bury any greed, hatred, and jealousy. So the deliberations would have been done without weapons and in peace. And then the last symbols were given is that the peacemaker took an arrow from each of the 5 nations and bound them together. In this way, the nations were united in their powers and their union was complete. Each nation retained their own council with the chiefs, chosen by clan members of families holding hereditary rights to official titles. The rights and duties of chiefs are explained to them as they stand up as chiefs, and it is the clan mother who maintains his moral obligations and keeps them in a straight line. So that's another important part of the Haudenosaunee Confederacy, is that it was a matriarchal confederacy. The clan mothers were the ones who instituted the chiefs and also were there in the moment. So we're going to see a wampum in a minute, but if you were to sit there, there would have been a tree and a circle around them and a chief of each nation or a clan up front, and they were the ones speaking. But just behind them was the grandmother, who was always able to and had the authority to tap them on the shoulder to make sure that they were following that straight line in the direction of peace, and if not, had the authority to replace them in the moment and put in someone else. And so from a settler perspective, they always saw male chiefs were the ones coming to the negotiation tables, but behind them were always the women who actually had the authority of the structure, the formalism of how it went. And they were the ones who ensured that that great law of peace was being upheld. And so sort of to commemorate this whole process, one by one, the peacemaker took wampum strings, one for each of the laws of the Great Peace, and described what each signified as he was binding this wampum together. With this action, the Great Confederation of the 5 Nations was formed. With his mission fulfilled, the peacemaker vanished, promising that if the Great Peace should fail, the people were to call his name in the bushes and he would return. So even within this story, I think there's a parallel to that call to action 45. We are clearly in a place where the nations in Canada isn't following the Great Law of Peace, and we need to return to those protocols and procedures. And part of that pathway is of this Great Law of the Peacemaker. I think also important to note within this is part of this process is a condolence ceremony. So if any of these nations were to find themselves in disagreement, there is a condolence process for the circle to gather and for the harm to be put before the council and the confederacy, and they would have open discussions about how to resolve that harm. So the sentencing circles, which some of you may have heard about, follows that protocol under the Anishinaabe folk. And for those of you who've never heard of wampum before, I thought I'd add this slide because a few times I've given this talk and folk had not heard of wampum. So wampum are belts, as you can see here, sort of beaded with the shells. The shells had a variety, but they were often the quahog clam shells here, so they had that purple whitish hue. And at other times they would be dyed for different colors. So I'll show you some more wampums that will have different pictographs on them in different colors. But the formal sort of wampum is these ones. And they can be more simplistic or more ornate, just depending on which belt it was. And this is the wampum belt, which describes the peacemaker in the Great Law story as I just described there. So you can see the great white tree in the center, and the other nations are represented by those squares. And within that, there was the keeper of the East and the West. And so within that confederacy, there was different obligations between the nations on what their responsibilities would be for the confederacy. And so wampum belts would have been brought out at every time there was a gathering. And they're also a pneumatic device. So that whole peacemaker story is contained within this belt, and knowledge keepers would be and have the responsibilities to present this story at any gatherings. And again, this was long before settlers were on Turtle Island. And this is that circle wampum that we described. So it's a little more rudimentary than some of the more ornate ones that we will see. But this is the circle wampum that the peacemaker wound to describe that great law of peace. So the circle wampum is important for the Haudenosaunee Confederacy. The equal strands of wampum represent the 50 chiefs, each chief being equal and united. The one longer strand represents the people. When we are born, our heart is in the middle of the circle, and as we grow, the chiefs and the people work to keep that circle strong. The chiefs are said to be holding hands, creating a large circle. Inside of that circle are the ways of the Haudenosaunee, the language, ceremonies, and culture, and the ways of life of our people. The people inside of the circle follow the ways set down from the Creator. It is the responsibility of the chiefs to protect and continue the ways of the Haudenosaunee. If a person does not follow the ways of the Creator and the Haudenosaunee, they are said to have left the circle and no longer under the protection of the 50 chiefs. So this wampum, again, is that pneumatic device. The knowledge keepers would have known which each strand represented which each chief. They would have also gathered in this exact formation when they did meet in person. And then it's also an ethics, so a training for the way of life. So part of the creation story is that you are born in the circle of this. You are surrounded by the knowledge of your people, and the chiefs are the ones who would instill that you would get that knowledge and live in a good way. So hopefully that kind of brief story is enough of an illustration to show that Indigenous political diplomacy existed long before the arrival of Europeans, and it was widespread among tribes. It wasn't located in just one part of Turtle Island. Peace and friendship was brokered between the Anishinaabe and Haudenosaunee as early as 1701. So another example of sort of pre-Confederate treaties between Indigenous nations. The Anishinaabe and the Haudenosaunee were sort of at war over a variety of reasons, but they met and they came up with their own treaty and their own understanding. So the agreement was orally transacted and is recorded on a wampum belt. The 1701 belt has the image of a bowl with one spoon, and it refers to the fact that both nations would share their hunting grounds in order to obtain and retain food. The single wooden spoon in the bowl meant that no knives or sharp edges would be allowed in the land, for this would lead to bloodshed. The agreement is still remembered by those two nations today, and this peace treaty was confirmed with wampum at Lake Superior in 1840. So before they made this belt, there was still the agreement. They continued to renew that relationship, and then in 1840, they agreed that this would be the representation of the bowl with one spoon. So you'll see the circle to represent the bowl, and again, that spoon. So there's no sharp knives or dealings between the nations over this specific territory. This next belt, hopefully some of you folk have heard about. This is the two-row wampum belt, and it symbolizes a nation-to-nation relationship. And so you can see that these beads are dyed a little differently than the natural coloring of those shells, and this was common practice as well. So one of the first recorded histories that we have of this is from 1613. The Mohawks noticed peoples coming into their territory unannounced. These were the Dutch. The visitors had begun to cut trees and clear land for their homes and farms. They had entered the lands of the Haudenosaunee and were now occupying some of their empty rooms. After some difficulties, the two groups had a meeting. At that meeting, it was discussed that a delegation must travel to where these people had settled to determine their intentions. As you can imagine, that was difficult for the delegation. The people they met spoke in a language they hadn't heard before. It took much time and patience for the two peoples to begin to communicate. After many discussions, it was decided that the Haudenosaunee and the Europeans must have a way to greet each other when they were to meet. The settlers with their large sailed boats thought that they should be called father and the Haudenosaunee son. The Haudenosaunee said that this would not do. We shall address each other as brothers. This shows that we are equal to each other. As the Haudenosaunee and Dutch discovered much about each other, an agreement was made as to how they were to treat each other and live together. Each of their ways would be shown in the purple rows running the length of the wampum. In one row is a ship with White Brothers' ways, in the other a canoe with our ways. Each will travel down the river of life side by side, and neither will attempt to steer each other's vessel. So it's a recognition of sovereignty, legal jurisdiction, but also peace and friendship. We are traversing the same waters, the same lands, but we can do that together in a good way. So moving on from there and getting into the Treaty of Niagara portion, this is the Royal Proclamation, obviously a complex settler colonial document, but it has been argued to be the Magna Carta of Indigenous rights and Aboriginal title, in that it acknowledges that Indigenous folk had their own territories and lands and their own sort of jurisdiction. So the Royal Proclamation of 1763 was issued by King George III of Great Britain following the British conquest of New France and its resulting secession to Great Britain in the Treaty of Paris, recognizing the rights of Indians to unceded land in their possession, protecting the Indians' interest in those lands, and providing that the rights of the land could be ceded only to the Crown. So placing this in history, this is when the British colony had tried to take over all of what we know now as North America. Many of the indigenous nations that fought for the French against the British had already had a covenant chain earlier than 1763, but were also invited to this because the British Crown knew that they were only going to be able to sort of hold on to their control of Turtle Island with the support of their indigenous allies. And they needed to bring on those who fought against them in the French and English wars. So our Supreme Court in Arvisuri has described the proclamation as a solution to the problems created by the greed which hitherto some of the English had all too often demonstrated in buying up Indian land at low prices. The situation was causing dangerous troubles amongst the Indians, and the Royal Proclamation was meant to remedy this. The proclamation represents the Crown's formal recognition of Indian interests in land and to protect such interests from third parties. Although the proclamation confirms the existence of Aboriginal title, it does not create it. Aboriginal title exists independently of the proclamation and arises from the historical use and occupation of Canada by Indigenous peoples. And another historical note of interest is that a few of the founding fathers, including George Washington of the US, had the job title of Indian land speculators and were often purchasing lands from indigenous communities not at full price and not under the best circumstances. So the proclamation would make it so they could no longer get into these agreements on their own in their own business. They would have to ask permission from the Crown and get a license to purchase those. And so when we're thinking about the American Revolution, I think we need to discuss those sort of facts as well, because that seems to be a much larger motivator than some of the other taxation without representation issues that we hear as part of the American narrative. So it's acknowledged that the proclamation is a complicated document. It is clear from the writing that it only contains a European perspective. In fact, we know that. The document was sent over from Britain without any changes in the published form that we still see. However, John Burroughs and other academic scholars have argued that the proclamation became a treaty at the negotiations which took place at Niagara in 1764. Sir William Johnson was sort of the crown agent, the delegate for all Indigenous relations on Turtle Island at that time. Sir William Johnson got an early draft of the Royal Proclamation and knew that he would have to explain it and translate it for their Indigenous partners. And so he did just that. And then he sent out runners to all of the nations that they were aware of and asked them to come to Niagara to discuss the new king's pronouncement. And we know that over 2,000 Indigenous peoples answered that call and met with him at Niagara and negotiated a new treaty. These negotiations reviewed and built on the promises contained in the Royal Proclamation, and that treaty was expressed in the Silver Covenant chain. So this is the Silver Covenant chain wampum. Of note, it's the first time we see numerals on a wampum belt, and this is because this was made by the Crown and offered to Indigenous peoples. So a clear example of the Crown acknowledging Indigenous legal orders, Indigenous jurisdiction, and respecting them to such an extent that they created basically a document to present to them and saying, this is the relationship we want to build, this is what we're offering. And so you'll see in the center there are two individuals, one representing the British and one representing the Indigenous nations. They are holding hands, and their hands extend into those other sort of objects you see there, which would be representations of different nations. I can say we're still working on unpacking the language of these pictographs. A lot of this knowledge, unfortunately, was lost even to Indigenous peoples, given the residential school experience and the loss of knowledge transfer. But there are many nations working on this now. And again, unfortunately, you'll see many wampum belts in museums without the proper respect, and so there's a movement to reclaim those belts and bring them back to the communities. Also, due to the loss of knowledge, some of these wampum belts were buried with the chiefs because they became known as the chief's belt. But again, they don't belong to an individual. They are a living document that, if anything, belongs to the creator. But it's something that the nations have to know. So this is sort of blue on white if it was in color. But you'll see it's based on the same wampum design of all the other histories. And part of the negotiations that went on at Niagara was the discussion of what kind of metal should the the covenant chain be. So there was discussions of should it be iron or some other metal, and they settled on silver. And silver is a motif that is sort of throughout wampum history and relations. And this is because silver tarnishes, and you must polish silver for it to sort of shine. So they agreed that this would be a silver covenant chain, and that they would get together and polish the chain. And this would be a time where either nation could bring up grievances and ask for assistance or to join a battle. Yearly or cyclical meetings between the nations were a necessary part of any treaty-making process. And from an Indigenous perspective, there is an acknowledgement that relationships need attention and communication to be successful. The circumstances of the nations could change due to environment or political factors. So any agreement to terms may need to be renegotiated given circumstances. The signing of a treaty from an Indigenous perspective is not a static moment in time, an event. It's a process and a living document. And another interesting historical fact is they did get together to polish the chain for over 90 years. After Sir William Johnson passed away, his son took up that title and continued to meet and renegotiate the Silver Covenant chain. At Niagara, other belts would have been there. There was another friendship belt, and the Crown also presented a belt representing a tree, the great tree we heard about, connected to a sailing ship on the ocean, and that was a recognition that the king would bring bounty yearly to these meetings, and there would be gifts from the king. And that was a sign of the respect and why, and in part, the Indigenous folk joined in on this silver covenant chain. So even early on in this pre-Confederate process, there was recognition of the gifts of the Europeans, and Indigenous folk were early adopters of any technology or knowledge that came their way. By this time in history, we have Indigenous chiefs writing in Ojibwe already, so they picked up the written language of their own words before Confederation. There's notes to the British Crown and to the Catholic Church that we have in historic documents as well. So now returning to Call to Action 45 after all that history. So Call to Action calls on the government to jointly develop with Aboriginal peoples a Royal Proclamation of Reconciliation issued by the Crown. And that would be built on most of those ideas that we've been discussing so far this evening. And this call for a Royal Proclamation of Reconciliation based on that nation-to-nation relation would again not just be a promise from a crown, it's a promise to meet and to gather again under the sort of law of peace and the Silver Covenant chain specifically. And maybe I should also note that from an Indigenous perspective, if there was already a treaty, you wouldn't renegotiate those terms on the next treaty. Instead, in ceremony, you would bring out those belts and the knowledge keeper would say, I remember when we made this promise and you said this and we are now bound by that. And then all of those belts would be explained and all those stories would be told, and then you would start negotiating new terms. And so when we get to the numbered treaties, from an Indigenous perspective, all of the pre-Confederate treaties were already agreed to and were still good law. And the numbered treaties was just the Crown asking for an extension of use of land, in a sense. So it wasn't, as our Supreme Court has decided, that the numbered treaties are just land surrender documents. Instead, they are, again, extending that kinship relationship to the Crown, and that was what was happening from the Indigenous perspective. So even today, if you see Indigenous folk trying to speak with the government, they often don't want to talk to the Prime Minister, they want to talk to the Attorney General, because they're in a sacred covenant with the Crown, not the Canadian constitutional setup that we have. Our common law says that our government and Prime Minister and folk have all of the authority of the Crown now, but that's a common law decision, and that has not been affirmed by Indigenous folk, which is why you still often see Indigenous folk reaching out to the British Crown, because they remember the stories, they remember their relationship, and they're trying to renew that. I remember during the Idle No More days, even CBC was having difficulty understanding why all of the folk there didn't want to talk to the Prime Minister, and this is one of the main reasons why. So in part of my framing of this whole sort of thing is also a civics education. So we can't really talk about the Royal Proclamation of Reconciliation because we don't have this as part of our civics education. So I co-authored a paper a few years ago entitled Indigenous Course Requirements, a Liberal Democratic Justification, where we use the idea from John Rawls and what he calls constitutional essentials. All right. I went a little fast, so I think I have time for this one. Sometimes I don't by the end of my talk. So, yes. So my apologies. This is for a philosophy of education paper, so it's full of terminologies and such. But if there's any questions, I'll try to unpack them at the end. So we argued in our paper that in liberal societies, these constitutional essentials include knowledge about the right to vote, the scope and limits of religious toleration, legal principles about non-discrimination on the basis of gender, race, or disability in the workplace, for example. As Rawls says, constitutional essentials at least include fundamental principles that specify the general structure of government and political processes, the powers of the legislative, executive, and judiciary, and among other basic rights and liberties of citizenship that legislative majorities must respect. So Rawls nowhere gives a complete account of what a constitutional essential is, but we argued that in Canada it's clear that this necessarily would include a great deal about the ways in which our Constitution and common law has been shaped and influenced by relations between colonial settlers and First Nations, including Inuit and Métis people. The Manitoba Act has an interesting history as well, and whether we want to think about that as a treaty as well is something that some scholars might want to argue. But including knowledge from these Indigenous contributions is key to understanding treaty agreements and other foundational aspects of our legal system, as discussed by Burroughs and Saul. So according to Rawls, knowledge of constitutional essentials is necessary because it enables citizens to ensure and sustain fair terms of cooperation in their relations with the rest of society, including with their fellow citizens who adhere to diverse and potentially conflicting moral, religious, and cultural commitments. More specifically, knowledge of constitutional essentials helps us sustain two key political values: the capacity of citizens to have an effective sense of justice and the value of political legitimacy. So these essentials is necessary for our citizens to have that effective sense of justice. As Rawls notes, knowledge is necessary in order for citizens to properly understand what is and what is not a crime in any society. An application of this point, ignorance of these constitutional essentials leaves citizens vulnerable to unwilling wrongdoing, including unintentionally oppressing or acquiescing to the oppression of fellow citizens. And having an effective sense of justice implies that citizens are able to do more than simply comply habitually with whatever laws happen to obtain at any given time, however unjust those laws may be as well. It also implies that citizens are capable of critically reflecting on competing interpretations of the laws to which they are subject, particularly when such disputes are adjudicated by political and legal institutions historically controlled by settlers whose impartiality remains deeply suspect from Indigenous perspectives. So put another way, liberal justice requires that citizens develop at most a provisional disposition to comply with existing laws. They should also pursue justice-oriented social change through legal channels where possible. And so further than just enabling an effective sense of justice, knowledge of constitutional essentials contributes to strengthening the conditions of political legitimacy in liberal societies, particularly in cases where a history of settler-colonial relationship between Indigenous and non-Indigenous citizens puts considerable strain on those conditions. The concept of political legitimacy concerns the conditions or circumstances under which the state's coercive authority over its citizens is morally acceptable or justified. And in liberal societies, political legitimacy depends crucially on the reasoned consent of all citizens. And I would say that ought to be an informed consent. That's what we're trying to argue here. So the exercise of political power is fully proper only when it is exercised in accordance with a constitution, the essentials of which all citizens, as free and equal, may reasonably be expected to endorse in light of principles of common ideals accepted to their common human reason. So with that sort of civics piece, I'd say in Canada, our political legitimacy is in question. Are we still grounding our legal authority and sovereignty on doctrines of discovery? I don't think we have to, but our common law case law seems to suggest that's the case still. Instead, we should look to our pre-Confederate history and those relationships that we had as the Crown with Indigenous peoples. If we don't, then we won't be able to get to a place of mutual respect and mutual civic discourse. So at the moment, how are we even going to have these discussions if most citizens don't know this history? How can we talk about reconciliation without first unpacking and knowing all of this truth? So to provide that reasoned consent under this sort of liberal framework, it seems that citizens must know most of this history that I just unpacked. And in no small part because most Canadians don't know about these contributions to our constitutional foundations and these sacred relationships that are still live and ongoing. I think it's interesting to note that the Indigenous perspective was always one of welcoming the stranger. It was one of an acknowledgement that any of their constitutions were living documents, and that's sort of where we ended up in our Canadian common law as well. We recognize that our Constitution is a living tree and that some branches will wither and die, but the root of that tree will stay strong if guided sort of by those foundational constitutional principles, which is exactly what the Great Law of Peace says as well. So there are some intentional and potentially unintentional convergences between Indigenous legal orders and our Canadian common law, but we can't really unpack that until we can have a more sort of reasoned and informed discussion. So I think I'll end it there. I'm almost at time, and I'll leave it open for some questions now. Should have just went back to the beginning.
Okay, question over here. Just hand you the mic if you could speak into the mic so our friends on Zoom.
Hi, yeah, I have a bunch of big questions, like what about the French? And what do you mean by crown? Who, King, the new King Charles? But I think it'd be better if I just start with a simple question. Where are all these beautiful wampum belts, and can we go see them, like, are they on display or what?
Well, most of them are reproductions that we have. The originals, if we do have them, would be housed at the nation that has that knowledge. And as I said, there are big projects going on to reclaim those from museums and potentially to exhume those and get them back into the communities. But the right place for them is with the community and the knowledge keepers that have that. And to your larger questions, what crown are we talking about? Great question. We do know that from the Silver Covenant chain story that I unpacked, all of those who joined the French joined the British during these negotiations. That being said, I think, I'm not sure if you're familiar with the Quebec reference case from our Supreme Court, but that was at the time when Quebec was trying to leave Confederation, and our Supreme Court gave this very beautiful description of what Canada is and what we ought to be and how we want to be multi-linguistic, multi-juridical. And since that time, around '93, Indigenous advocates and legal scholars have been saying yes to all of that, but for us too. We agree with all of these things you're saying, Canada, but you haven't extended that mutual respect and recognition of our languages and our laws. So I think under our confederacy, this would be the thing. Let's bring everyone together, French, English, Métis, all the First Nation folk, to these meetings and gatherings and say, what do we want to do as a country? What do we want to do as a constitution? And can we bring in any other folk who weren't part of those original treaties? So follow those roots back to the Great Tree and see if we can all come to an agreement. If not, that's fine, but there's different protocols and methodologies and places for those things.
Education is the new bison. And I'm sorry that it took me until my articling course, which wasn't done online at the time, so we were able to really grab them by the throat and ask questions, to find out that this Washington situation of buying up the land at cheap value actually extended to Manitoba. And Aikens was founded on the money that was built on buying up worthless scrip and taking people out of their land. The concern that I have about Rawls is that he's so freighted with jurisdictional colonial settler legalism. Mm-hmm. To me, it's more of a body politic that we're talking about, that we have to somehow combine on a body politic basis. And then eventually, once we've come to terms, to incorporate this into a common language of law. What I'm interested in is also the unceded lands and the fact that I don't accept that any of the original treaties were done with good faith on the, it's called settler, but it's basically the dominator side, you know. Mm-hmm. The people who are going to come and envied them of everything they had and wanted it. It was beyond greed, it was envy. So, you know, I don't know if you've had a chance to see the recent documentary, Twice Colonized.
No, no.
I hope you can have a chance. That's about the what do you call that, circumpolar groups. Mm-hmm. And I hope everybody will see it, because I think it has a lot of reference. But if you could give an idea with regard to, I appreciate that we look at legal scholars like Rawls, mm-hmm. you know. But as I say, I consider him to be not legitimate in many respects.
Sure. Because
he's coming from a legal point of view of a constitution that I still see as being imposed.
Yeah, thanks for that question. Yeah, our paper was clearly positioned for those who already agree with liberalism as sort of being the best form of government, and we cite that in our footnote. We're not here to argue whether liberalism is the best, but we're going to just take this one idea from Rawls because it seems that it just follows logical sense. If we're going to have a constitution and a jurisdiction, that the citizens under that need to understand those laws, and so that simple constitutional essentials piece is all we're trying to hang our hat on. We actually argue from a position of mutual aid frameworks more often than not, and that's some of my first publication work is on that. So a recognition that evolution itself is based on mutual aid, not mutual struggle. Mutual struggle is that scarcity, colonial, social Darwinian idea wrapped up with all those eugenics and state of nature talk. So I will want to say Rawls is guilty of all of that. He's going to talk about the state of nature. He's going to talk about the individual as an individual radically separated from each other. Indigenous perspectives has that mutual aid perspective, which is we're interdependent beings. From Anishinaabe creation stories, we're the last creature of creation. Everything else is ordered and is living in a good way before we get here. And it was acknowledged by the Creator. Well, it was actually the Creator warned the animals and the rest of the kin that humans were coming and they wouldn't know themselves and they were going to need help. And that the Creator asked all of nature and all of our kin to help us through that. So again, that place of bounty, not place of scarcity.
Thanks for clarifying.
Yeah.
Because I've done a broader reading of Rawls and
Yeah.
it was challenging to my brain.
Yeah, we also talk about Dewey. So what we tried to do with that paper was who are we still citing in our education? We're still citing Rawls, we're still citing Dewey, because that was a philosophy of education paper. Dewey is the biggest sort of name out there still, but he still didn't acknowledge the Indigenous education that was right in his New York area itself. And we actually argued if he did, that he would have kind of agreed with a lot of it in some sense, but would have that interdependency issue kind of coming from there. So I have my philosophy degree from U of W, which is much more of a history of ideas program, so I'm much more of a historian. So when we looked at these works, we don't just read the arguments, we read the collected work and talk about the political environment of the time, so we get a better sense of how these ideas shaped all of this. So with my philosophy education and my law degree, I basically have the history of dispossession of Indigenous folk and which ideas were used to sort of prop those up. And I can say we still talk about John Locke in property, and somehow mixing my labor with the land gives me the right to take something as my own. But then we've secularized it to the point where we don't say that essential piece in the Locke argument, which is God guarantees this, because you're actually God's property. So we wanted to target all of those thinkers that we still use in our education, not necessarily contemporary thinkers which have refined this, because obviously folk are working on Rawls and trying to find better ways to save liberalism. And I could say I am a fan of constitutionalism. I'm not sure if we need all of the presuppositions of liberalism to get there, though.
Mark, there's a question on Zoom. I'll just read it out. So how do we start teaching these ideas to the younger learners to take it out of these high-level ideas and bring new generations into this knowledge of what constitutes civic understanding?
Well, thankfully, a lot of it is just narrative. We can just tell these stories. There wasn't any argument in that great law of peace. It was just, here's a bunch of sort of facts. We can talk about what these mean in different ways. But a lot of Indigenous legal orders are contained in story. And there's nothing more sort of engaging than story over these sort of complex legal arguments or something. So I could say since the TRC, definitely since 2015, most of our K-12 education has started to include, at least discussions of treaties and residential schools and 60 Scoop and all of these sort of facts. And so, they get the contemporary trauma piece, and definitely what I think we need to add to a lot of these is this history of heroes who were uplifting Canada. So we know that there's 2,000 nations, but who were the names of those chiefs? It wasn't that long ago. We should be able to find that out with enough research, and maybe that's on my end too. I definitely know I need to do more research in this area. I often just echo the work of John Burroughs, so if you want a more detailed account, I'd highly recommend most of Burroughs' work. His law course is online for free as well on YouTube. And then further, for youth, I can say at the law school, we've developed high school programming. So we partnered with the lawmakers and the wayfinders. So we mentor through an externship about 20 to 25 North End students through their high school legal class. And then our students give a more sort of detailed and focused lecture in the evenings. So we're looking for a lot more engagement before our students even get to universities. Especially because representation matters. So often just being Indigenous and a lawyer going out to spaces and saying, this is a possibility for you as well. So a couple of weeks ago, my researcher and assistant and I just went to the powwow at Marymount just to try to get our presence known. And we're trying to get a lot more of that engagement from Robson Hall so we can go out to community. Too often, the law school and the university proper is sort of an island. And most of our research has been extractive. There hasn't been a lot of return to any of the communities or individuals when we do our research. So everything now that U of M is trying to do is taking Indigenous protocols into place. So we're having policies and procedures coming out of VP Indigenous on how to do good research. If you're working with communities, you have to go through the ethics department to make sure you're doing that in a good way as well. But coming back to the question, how do we get this to young people? I think we have those stories, and there's lots of interesting stories. We can talk about tricksters. There's a multitude of sources depending on the topic in which we can do. And then lastly, art. So there's lots of art projects that can be done, and I've seen some really good ones with sort of bricks representing every student in a residential school, and the students actually putting them all up on the wall to sort of get a scope of the problem visually. And I know at U of M here, our Advanced Center of Teaching and Research is trying to put more resources available for teachers to use in their courses. And if you do a quick survey online, most universities and Indigenous nations have some sort of material that you could use. So, but yeah, mostly these discussions as well.
Oh, okay. Hi there, Mark, you know me. I have a question. I'm Mark's research student. Okay, so yes, familiar with Wampum. From being in the States, they actually teach about Wampum in our American history courses, even in middle school, which was amazing. I grew up in upstate New York, very familiar. But going back to this and knowing that Wampum is a living document and it's something that contains, an oral history and an underlying story, there was acknowledgement by the Crown because they've used that themselves at the time to be able to, reaffirm the relationship and that they were having there. But now, where are we sitting with that? I mean, I know there's been a lot of loss of history and things because of the residential schools and displacement and, getting the Indian out of the Indian with residential schools. How do we come back to that, and where is it in law now? Has it been used? Can you point to where it's been used in terms of the wampum itself and oral histories? And then just another thing I wanted to add. In school, one of the ways they used to teach us about oral history is we'd have items, and they'd have different symbols and rows of beads, just like you can imagine a rosary or wampum, and each tile or each bead would be a word that we would have to remember to be able to tell a story. And that's how we would do it. We would touch everything and say, the canoe went down the Red River, 2 people were in the canoe, they were going towards the forks. And it was just kind of a neat game, and I just wanted to speak to being able to teach children how to understand how oral history started in terms of these documents. Thank you.
Yeah, that's great. Maybe I'll start with the last point, that wampum, as I noted, is wampum belts are pneumatic devices. So you can teach it, as Cody just mentioned there, that you could talk through that process if you had the knowledge keeper who is authorized to give that story and could sort of facilitate those things. Coming back to the oral histories, we must remember that oral histories were disallowed in common law courts under the hearsay rule for many years. It's, I think Vanderpeet is the first time we've acknowledged it. Before then, they just said it was hearsay. And unfortunately now, when knowledge keepers come in, they're considered experts, and so the first thing you do is cross-examine them on their credentials, and that is not the way to respectfully treat knowledge keepers that have these Indigenous legal orders. So whereas common law right now with the treaties, I'd say still in a place of disrespect and lack of understanding, which is why I want to focus on this call to action 45, because this is a moment where we can gather together again and ask ourselves these questions. Because I don't think one nation has the correct response about how we move forward in this relationship. We have to gather to have those discussions. And it's not going to be a week-long meeting. This is likely going to take several gatherings to even get a provisional understanding. I could imagine, 2 weeks just to decide what protocols we're going to follow. Nothing about this is going to be fast. As the Honourable Murray Sinclair likes to remind us, it took us 7 generations to get here. It's likely 7 generations to get out. So there is no fast fixes to these problems. All we can do is try to be better learners and be more open to difference of opinions and worldviews and find a way within that to have that mutual respect for dialogue.
Do you want to, there's a question.
So we have another question from Colin. He says, I live in Australia, which has never had a treaty or treaties with Indigenous peoples. There is to be a national referendum soon to change the Constitution to recognize Indigenous peoples and create a voice, composition to be determined by legislation, which can make representation to the Parliament and executive government about matters affecting Aboriginals represented by the voice. As with First Nations in Canada, there were many Aboriginal tribes and clans. Is having a single voice a good idea? And should there be a Truth and Reconciliation Commission before considering a voice or a treaty?
Yeah, that's an interesting question in the sense from that Australian perspective. So when we talk about truth and reconciliation in Canada, I think that Treaty of Niagara is something that we can reclaim and return to. So I do think it's a specific history to Canada. I'm hesitant to say that we should have one voice for Indigenous peoples, as that's sort of what settlers have been asking for. Part of the residential school was to sort of kill those personal narratives, that actual individual sovereignty. That being said, I think there's many signs that First Nations can organize themselves together. We have the Assembly Manitoba Chiefs just here, which includes most nations in Manitoba. There's larger national organizations. I think we can look to the history of our Constitution itself in '82, when Indigenous people demanded to be included in those discussions, and that's how we got Section 35 in our Constitution. So I think that voice question is actually a question for the First Nations, and they would decide how they want to represent and present themselves to the Crown. But I think the Royal Proclamation on Reconciliation is asking, let's return to that Niagara Protocol and procedures. So at first to call those nations, but I would make it an open call to all First Nations on Turtle Island. We have to remember even the border between US and Canada is a colonial construct, and many First Nation folk just across the border would and likely want to participate in these discussions as well. So aside from those pan-Indigenous concerns, obviously political unity amongst nations is necessary. That's what we saw in the Great Law of Peace. These were disparate nations that were fighting and warring, and the peacemaker came and brought them together, united under a single vision of peace. So for that Royal Proclamation of Reconciliation, I think that's what the ask is from the Treaty of Niagara folk. What other nations want to join us in peace in this belt? You don't have to. Other treaties and other negotiations could be done, but each document, again, is living. So to return to it would demand that those original partners be part of those discussions and which nations they were. And so that's why I said part of that research is unpacking which nations were signatories, in a sense, signatories in, in sort of my English verbiage there, but joined in that relationship.
I think there's a gentleman over here who had a question in the maroon sweater over there.
So I'm pretty, this is all new territory to me, so my understanding of the original treaties that you made was everything was seen as sort of more or less equality, which then changed. You brought up the point of the Indigenous community members trying to speak to connections to, I believe it was royalty and I guess the people they had originally created their treaties with. So I guess now, what is the, I guess in the eyes of the Canadian government and our law and other institutes, are the Indigenous people considered citizens of Canada, or are they considered members of their own communities and, of their own peoples? And then if they are still actually members of their own communities, how is it equitable that we impose our own laws and other processes on these people? I'm not overly familiar, so.
Right, so it's a good time to remind everyone and all Canadians that we're a constitutional monarchy, and that the King is still the head of state, and all of our legal authority flows from the Crown, which at the new King's confirmation still includes the Christian God as the justification for that authority. And so a lot of our understanding of secularism in Canada, I think, is a myth as well. Even in our 82 Constitution, God is in the preamble, like page 1. So there's that. Two, yes, not every First Nation was part of these early pre-Confederate history, obviously. And actually, I would say all nations consider themselves unceded territory. These weren't land surrenders. These were peace and friendship, kinship relationships. So that's why 45, again, to me is so important, because it says, let's have these gatherings based on the protocols of the Treaty of Niagara. And that's at a time when the Crown recognized Indigenous legal orders and made that Silver Covenant chain themselves. And as to the other point, assumed Crown sovereignty has just been the lay of the land here since Confederation. Even if Indigenous partners didn't consider themselves part of Confederation, Canada does. So Canada considers all First Nation citizens. Now, it was used as an assimilation tool pre-sort of 1950s, when if you were on a reserve and you had your status, if you wanted to vote, you had to give up your Indian status to do so. We've made some changes to the Indian Act, so now people who lost their status due to that can take that in again. But it's still gendered issues, and women have been fighting for rights of equality under that too. If an Indigenous woman married a Métis man, they lost their rights, and so there's discrimination against Métis people within that too. So there's a long sordid history, again, of dispossession of Indigenous peoples' sovereignty and lands, and that's part of that reconciliation piece. But another important part of that great law of peace to remember is there is a condolence ceremony. So there is an Indigenous methodology and protocol for this, and that is the condolence ceremony. And so that would be an opportunity for each nation to bring their own their own call for reparations of harm, and say, these are the harms that you've done to our nation specifically, and this is what we want to see happen, or how we want you to change your behavior. And there's different protocols under that restorative justice as well. And so it's a process, I guess I would say, and so we need to start it again and renew that nation-to-nation relationship. And that's the only good way to go forward. But do some nations not want to be part of Confederacy, and do they want their own sovereignty? For sure. Many nations have that point of view, and all of those are valid. So like I said, this all has to be part of a larger national conversation, but all Canadians need this truth before we can even start having these conversations. So we're still at the early days. Truth is going to take at least a generation before we get to real reconciliation, I feel.
Thank you. In view of the person calling in from Australia, I have some strong roots in Australia and the Indigenous people position there and their struggles. And in terms of getting one voice, it would seem, in terms of also what you've been speaking, and I'm saying this so you can hopefully make some comment on this, that in view of the 45 action, before any kind of voice is brought forward, singular or otherwise, there has to be a truth and reconciliation process and the acts of condolences. If it's good enough for South Africa and it's good enough for Canada, I would hope that this is something that's being taken up wherever Indigenous people are oppressed. And there are other countries as well, particularly South America, Mexico, and so on and so forth. So in view of 45, I would ask if you wouldn't mind responding to that, because that was the end of the question was, should we have a truth and reconciliation? I think it ties in nicely with 45.
Right. I mean, I'd say we are in the Truth and Reconciliation era since at least 2015 when the official report finally came down. We have our National Institute on campus here, which is working towards all of these sort of goals as well. So I wouldn't want to say that there is like one process. There's going to be a multitude of meetings and gatherings and condolence ceremonies. I pulled out the Treaty of Niagara and that specific history, one, because I do think it formed Canada, and two, it's also part of the TRC call to action, so other folk, other Indigenous nations and people want that as well. The one voice idea extending to sort of international communities, I think, is an important one. I was just at the Indigenous Studies Conference in Toronto, and we had representations from every sort of continent in the world represented there, all sort of working on different reconciliation and truth processes. It's not just the British common law, which was oppressive. The law has been the main tool of oppression in any jurisdiction ever. That's just the way that the law works. And unfortunately, in most jurisdictions, it's been to criminalize the poor and empower the rich. And whatever intersection you happen to fall into, that's a larger sort of problem. So, as a philosopher, political theorist, obviously there's some class issues, there's some race issues, there's some gender issues. All of these things are going to be at play, right? We do need an intersectional approach to all of this, but I think that's part of that mutual aid and mutual respect is what position are you in and where do you speak from? So positionality is always going to be important for all these discussions too. But from the First Nation perspective, we're all talking to each other about how things are going in New Zealand and Australia, and some of the successes on personhood for waterways in other jurisdictions now being used in Canada is a good sign that that's working. But there's other things going on that we're all trying to get together on, for sure. So I just think there's that pan-Indigenous frozen in time issue. So as long as we're not talking about there's going to be one Indigenous voice, then we're fine, right? As long as it's that intersectional mutual aid framework, we'll be okay. But clearly, a Truth and Reconciliation process modeled on the Truth and Reconciliation Commissions that happened before was the intention of the Canadian one. That's why we have the Truth and Reconciliation process, because we wanted to build on the successes that happened elsewhere.
Marc, as you can, as you can see by the interest of all these questions, there's a great question here. Can people audit this second-year course that you've referred to in the fall? So can all of our alumni here participate in some way?
I don't think we're set up for that right now. We just taught it for the first time this year, because anytime you put a new course forward, you have to teach it as an elective first. So it's going to be mandatory for the first time this year. And so we're going to have our whole 115 students in one class. Some of it will be recorded, some of it won't. So I don't think we'll be able to audit that class at the moment, just because it's so sort of new. That being said, we are trying to develop more programming and more things like this, where some of the knowledge that's in those classes will be available to the public. And also like U of A, U of S, there's other sort of free education programs which will talk about some of this history as well. I think there's some of our programs starting up right away, actually, if you want to look for that. But yes, everything that we do, we want to get back into the community as well. And so we'll hopefully have more of this hosted. It's my understanding that this talk will be hosted online for a while for other folk to go to it if they weren't able to join us tonight. And so more initiatives like this is what my intention is.
And Colin has responded to a comment. The current government is committed to proposals to a Truth and Reconciliation Commission, as well as a treaty, as well as a voice, but have indicated its priority establishing a voice and constitutional recognition first.
Right. Yeah, and I think that's the point, right? We need that these discussions to happen. And so there's work on the First Nation side about them gathering and deciding how each wants to proceed. Again, I don't know if there'll be a unified nation or one voice. I do envision likely a multitude. And in part because there's different histories, right? Like the Anishinaabe folk, Anishinaabe are part of the Sacred Covenant chain. So trying to break that or get around that would be difficult, where some folk in BC who aren't part of that agreement and have always been fighting and claiming unceded territory, they're in a different position politically and legally, I think, at the moment, which is often why we see most of Aboriginal case law coming out of BC, because our common law has treated all of the numbered treaties, meaning most of Canada, as land surrenders. So we don't have to worry about the assumed crown sovereignty anywhere but BC and some of the places they've had to do modern day treaties.
In the Australian context, they would
Right.
the Australian context. I mean, the more that they can bring together the various Indigenous people, I would hope that that would be the route to go rather than imposing a voice.
Yes.
Imposing it as a constitution.
Right, so the comment is just that the First Nation folk decide the voice, not have an imposed one from the settlers. So, and that's that pan-Indigenous concern I have. The Crown often coming to Indigenous nations saying, we want to just talk to your chief, or we just want to talk to that one person who can be the decider for the entire nation. And that's not going to happen. So that's all I was trying to be clear about.
Okay, last question.
Looking at this with the Niagara Treaty, etc., my question is, for the call to action for 45 and the Niagara Treaty, what does this mean for the Indian Act itself, which I've always seen has a we white folk get to determine who you Indigenous folk are. And to quote my favorite thing, it's burn sage, sweetgrass, and the Indian Act.
Yes, that's fair. I think Canada in Canadian politics since the White Papers has been very scared to reopen the idea about abolishing the Indian Act, as many nations at the time saw it as some of the only protections of their rights and of their lands, the limited ones that they still had. I think we're in a different political climate today, but I can say most settler politicians probably remember that pretty well still and are worried about opening that up. But I think all of these constitutional questions is part of that because the Indian Act also gets its authority from Section 9124 of the Constitution, which says that the federal government has all the authority and power over Indians and the lands of Indians. And so I think that's where, if we're having these constitutional talks, we can say, let's reopen that discussion as well, and that's a moment to talk about the Indian Act. But I wouldn't want that to be a process that just comes from the common law civil perspective. It would have to be one that brings in Indigenous legal disorders as well. Because that's the main problem with the White Papers in the first place, was that it was just the Liberal government saying, hey, we're going to just scrap this, we're all equal now. Because that masks and hides all of that colonial history and oppression. But I do think we're in a better place now to have these discussions. And I do, as you note, there's slogans on shirts now. That's usually a good sign that the people are ready to have these discussions at least. Yes, memes. That's right. Indigenous TikTok, everyone. It's a pretty good place.
Okay, well, thank you very much, Mark. That was amazing, very interesting.
Smiglich, everyone.
So just a few things that I just want to share before you leave. The first one is our Today, the magazine, has just hit mailboxes. And so we do have a few. If you're not on our mailing list for some reason, let Amy or I know about that. But if you didn't get a magazine, there's a few that are at the front. And Mark has cited the Honorable Murray Sinclair a few times in his presentation. There is a wonderful article called Truth Teller about the Honorable Murray Sinclair and his story. So please do, I do encourage you to read that. We will be sending you an email tomorrow. That's just a follow-up thank you for being here with a few different things, including a survey to gather your feedback. We're always interested to hear, you know, the good, the bad, the ugly, other topics, things that you'd like to know about. But something that will also, so Mark has, this course that he's talking about and the various different scholars he's working with, we're really at the University of Manitoba, it's a priority for us in terms of advancing Indigenous truth and reconciliation and in academia in particular. And so we're establishing a chair in Indigenous law and economic reconciliation. And what's really exciting about this role is it's going to be the first of its kind in Canada. And it's going to be housed in the Faculty of Law where Mark teaches, but there's also going to be a strong connection to the Asper School of Business. And it's going to generate lots of really innovative, more research that you're seeing that you've heard today from Mark, and hands-on learning opportunities related to new and emerging legal and business issues impacting Indigenous rights. And so I'm sure you'll be interested in that. And so there will also be in that email a link if you're interested in contributing and making a gift to that particular fund. It does involve fundraising to get that chair off the ground. So we're hoping that you'll consider that support. Thank you for being here on this very lovely June evening. We do appreciate it, and have a wonderful summer.